Well, why don't we get started, everyone, and good evening. I'm Marcel Acosta, the Executive Director of the National Capital Planning Commission. And let me start by thanking the American Planning Association National Capital Area Chapter for partnering with us tonight. It's a pleasure to welcome all of their members and all of you and our guests to the National Capital Planning Commission as we kick off our 2014 Speaker Series. And whether you're a keynote speaker or a panel of experts, since 2010, we've used the Speaker Series to highlight a great variety of contemporary planning issues important to our region and to the nation. Perhaps more importantly for us is that these sessions really shape and inform our work here at NCPC. For example, our sessions on President Obama's executive order on sustainability help shape our Southwest Eco District Plan, our event looking at historic contemporary design issues here in the district and the region, informed development of our all-new federal urban design element, which is part of our comp plan, which is now under consideration. And our panel of international experts last year kicked off a year-long discussion of building heights in the district. So we've used these discussions as really a way to explore issues and really talk through many of the important things that affect our city and in our region. So tonight we really bring the conversation back to the fundamentals by looking at the legal foundations that actually enable us as planners to do our work on a day-to-day basis. We're all really aware of the unique context for planning in this region. The framework for planning is shaped by distinctly different legal structures in Maryland, Virginia, the district, and the federal government. We're all generally aware of some of these differences, but we're really looking forward tonight to a discussion from our colleagues in our esteemed panel to better understand the context for planning work that's being done throughout the region. So despite these various legal authorities, our region works well together to achieve shared goals, and I think that's really what helps us become a national leader in planning innovation. To help walk us through all the details, we're very lucky to have a great lineup of panels representing all of our jurisdiction, and our moderator for the evening is one of our own here at NCPC, our General Counsel, and Skylar, and she'll be introducing tonight's panelists. But before we get to it, let me turn the podium over to Shannon Hake, President of the American Planning Association National Capital Area Chapter, for a few quick announcements, including your credits, which will earn at the end of tonight's session. So thank you very much for coming.
Hello, I am Shannon Hake. I'm the president of the National Capital Area Chapter of the American Planning Association, and I am here to help you get your law credits. I know that most of you are here because you think that this is a fascinating topic, but I do understand that some of you may be here to fulfill your every 2-year law credit. So if you have something to write down, I'm going to give you a number, and that number will help you log these credits. This is event 25908. If you go to the American Planning Association website, search for that number. Again, it's 25908. This event will come up, and you must register your attendance to get credit for attending this event. The requirement is the law session is required once every 2 years. The ethics session is also required once every 2 years, and our chapter will be holding an ethics session at our June conference, so keep an eye out for that. I also wanted to mention that we have the chapter has a couple other spring events going on. We have a trivia night planned for mid-April with trivia questions focusing on DC and planning trivia, so if you think you're an expert, we encourage you to come out to that. Keep an eye out for that. We've got a volunteer event coming up on April 26th. It's going to be a tree planting with Casey Trees. And finally, we have our awards event this October where we recognize outstanding projects in planning in the National Capital Region. So we encourage you to keep an eye out for that as well. I'd like to thank very much NCPC for organizing this event and co-sponsoring this event with us. And we're very, very happy for you to be here. And on that note, 25908, again, number, please log your credits, because otherwise you're not going to get credit for being here. On that note, I'll turn it back over to Ann.
And operators are standing by. So, good evening. Tonight I'm going to get to cross another thing off my bucket list, and that is, depending upon your age, I get to play Johnny Carson, Jay Leno, or Jimmy Fallon. So, I do want to welcome you, and I know the great turnout is because this is such a fascinating subject, nothing to do with your getting your credits. But we're glad you decided to come out and join us tonight because we do have a very exciting discussion on tap, which is focused on the intricacies of land use planning and zoning law at the federal and local level. And we have 3 divergent local jurisdictions represented on our panel tonight for DC, Maryland, and Virginia. Our panelists are intimately qualified to address the issues by virtue of their professional backgrounds and their training. And in fact, several of our panelists have cross-jurisdictional experience, so they're knowledgeable about how another jurisdiction functions. So if I may, you've received, or you should have received, a paper with all of the dossiers on the various panels, but I just wanted to point out a few highlights for each. And I'm going to address them in the order that they're speaking, but they didn't sit in that order to my right, so they'll raise their hand when I call their name. Mr. Peter May, right here to my right, he's the Associate Regional Director for Lands, Resources, and Planning with the National Capital Region of the National Park Service. He serves as an alternate for the Secretary of the Interior, Sally Jewell, on the National Capital Planning Commission. He also serves as a member of the District of Columbia Zoning Commission, which by statute, and you'll hear about this later, must include a representative of the National Park Service. An architect by training, Mr. May has worked in the past for the DC government, the architect of the Capitol, and a private architectural firm. It's a very diverse background. Welcome, Peter. Next is Jennifer Steingasser. Ms. Steingasser serves as the Deputy Director, Development Review and Historic Preservation of the Office of Planning. She also serves as an alternate for the mayor on the NCPC, second to the Director of OP. And as you all know, with the directorship of OP vacant, we will be seeing more of Ms. Steingasser at our commission meetings for a while. As a planner by training, Ms. Steingasser has previously served as a municipal planner for both Texas and Virginia. Again, she has experience of another nearby jurisdiction. Next is David Lieb. Mr. Lieb is an attorney for the Maryland National Capital Park and Planning Commission, where he advises the Montgomery County Planning Board and staff on legal issues pertaining to land use planning and entitlement. Mr. Lieb also served as a legal advisor to the Planning Board during its rewrite of the Montgomery County Code. For those of you who know, the district is currently involved in a similar undertaking, and I suggested that David and Jennifer have lunch together and share notes. Prior to joining MNCPPC, Mr. Lieb worked as a private practitioner in Washington. He is a lawyer by training with an undergraduate degree in planning. I can relate to that. I have the same, actually graduate degree on my part. Finally, we have Sharon Pandak. I'm sorry, is that correct, Pandak? Ms. Pandak is a partner at Greenhand, Taves, Pandak, and Stoner, where she specializes in planning and municipal law. She also serves as general counsel to the Metropolitan Council of Governments, which, piece of trivia, is organized as a corporation. I never knew that until I had to prepare for tonight. Nonprofit corporation under district law. An attorney by training, Ms. Pandak previously worked for 15 years as an attorney for Prince William County in Virginia. So now, since this is a legal program, guess what? I'm given a disclaimer. Of course, you have to play lawyers. Each of the individuals tonight is appearing in their own individual capacity. They are not here speaking on behalf of their individual organizations. So therefore, we hope you will take that into account when you consider what the various positions are. So now, I would like to turn the program over to Mr. May. He will speak about the federal role in planning in the national capital. Take it away. Here's Peter.
Thank you. So if Ann is Jimmy Fallon, then I guess that makes me Will Smith, right? We'll do the dance routine shortly. Okay.
When did the wild animals come out?
So as Ann said, I have several roles, and in the context of what we're talking about tonight, that means that for the Park Service, I will represent certain projects, or I'll bring projects before NCPC and other approval organizations. So I'm an applicant. I'm also a commissioner on this commission, and then, of course, on the District Zoning Commission representing the Director of the National Park Service. Now, most of what I have to talk about are things related to the National Capital Planning Commission. It's mostly that role, and I guess I was selected for the the way I touch a lot of these different topics. The NCPC and the district share responsibility for planning within the district, and the NCPC has a role beyond the district as well. So within the district, planning powers are split between the federal government and the District of Columbia, and then throughout the region, the federal government has a role through a variety of other federal laws. The National Capital Planning Commission's basic authority comes from the Planning Act of 1952. Now, NCPC started long before that, 1924, as an agency charged with implementing the Macmillan Plan for the district. The Planning Act established the NCPC as a central planning agency for the federal government, and the key responsibilities are preparing the comprehensive plan, reviewing and approving federal projects, which for a commissioner like me seems to be the majority of the work, and then the Federal Capital Improvements Program as well. Another key act is the Home Rule Act, which is where the responsibilities were divided between the District of Columbia and NCPC. The mayor was designated as the central planning agent for planning in the district, and the mayor was charged with developing and implementing the district elements of the comprehensive plan. So what happened in the Home Rule Act is it amended the Planning Act to add 2 district members to NCPC, establish NCPC review for district elements of the comprehensive plan, including a veto authority over elements that would negatively impact federal interests. So NCPC does have a say over the district's portion of the comprehensive plan. And it also authorized an NCPC zoning authority over district public buildings within the central area. And that's, and actually the authority is more than just, there's other authorities that relate to zoning, and we'll get into that a little bit later with project review. Other federal laws that are an important part of the review, National Environmental Policy Act. Anybody heard of that? I hadn't really spent much time with NEPA before I came to the Park Service, and now it's a very big part of my life. Too big, perhaps. Section 106 of the National Historic Preservation Act, in particular, anytime an undertaking has an effect on a federal, on a National Register district site or building, Section 106 comes into play. Another aspect of my job that I didn't anticipate was going to consume a lot of my time, but I spent a lot of time in meetings with people addressing Section 106 concerns. I see a few familiar faces in the audience from some of those meetings, and thank you all for coming and hearing me talk again. The Commemorative Works Act is the primary control over the establishment of new memorials in Washington. Again, another one of the major responsibilities of my office. We work with all memorial sponsors that are authorized by the Congress to establish sites for the memorials and develop designs for the memorials and get the necessary approvals. And once the money is raised, we issue a permit for the construction of those memorials, and it can be a very long and hard process. Another important act is the Height of Buildings Act, and this is one that comes into play often with project review for NCPC. And the Foreign Missions Act and Capper-Crampton. Has anybody heard of Capper-Crampton? Nobody, a couple of people have. So Capper-Crampton was the bill that essentially authorized the acquisition of land for, related largely to the Macmillan Plan and the establishment of many of the parks in and around the district. And it was basically the vehicle by which much of the Civil War defenses of Washington were acquired, and also other parklands outside of the district. And when it comes to NCPC's role, this is one of the areas where the authority extends beyond the district boundaries more significantly anytime a planning action affects lands acquired under the Capper-Crampton Act. Excuse me, I'm trying to turn pages and advance the slides at the same time. So the makeup of the commission, you see at the top, the federal representatives, those are all agency representatives. In my time, 6 years, I've not seen any of the actual agency representatives, I mean the Secretary of the Interior or the Administrator of GSA. They usually don't make it. They have people like us who attend on their behalf. But there's often a lot of consultation on certain projects all the way up the chain, and so I've had discussions with the Secretary of the Interior from time to time on projects. The presidential appointees from the from Maryland and Virginia, and one at-large member. Congressional representatives, these are usually the staff members from the commissions, from the committees that have some say in district affairs. And then, of course, the local representatives, the mayor's mayor's appointees, and a representative, the chairman of the Council of the District of Columbia, and the mayor of the District of Columbia's designee. I have seen the chairman of the Council of the District of Columbia here at meetings. The comprehensive plan, which NCPC develops, includes these, the first 7 elements, and the 8th element, the federal urban design element, is still in development. And the district's portion of the comp plan, this is from the district's plan, and it shows a little bit better some of the district's components. It's a little bit hard to read, apologize for that. But what you can see is there's historic preservation and there's a park master plan and things. So there is some overlap on areas of interest, not necessarily specific land areas, although that can happen as well. And then at the bottom you see the federal plan, which is all of the 7 elements that I just showed, and the federal capital improvements program. Generally speaking, the NCPC authorities relate to issues specific to the federal government and to the functions of Washington as a capital city. So it will delve into issues such as foreign missions. Now we'll get a little bit into plan review, which is a big component of what NCPC does. And this map shows the area where NCPC has some authority. In the area in red, of course, is the district where NCPC has approval authority over federal land and buildings. As I mentioned before, the NCPC has approval authority over some district buildings, depending on where they are located, and has advisory authority over many other things in the district as well, many other district actions. And in Maryland and Virginia, NCPC's recommendations are advisory. Advisory is, I guess, is the technical term for it, but in my experience in 6+ years on the commission, that advice is usually very closely followed. And I can only recall 1 or 2 occasions when a particular agency resisted the advice of the NCPC. Now, typical review cycle is about 30 days for a project, although I will say that I've had some projects that, I have one project coming up in April that has taken, about 2.5 years to get to this point, but it's been complicated by a number of things. That's the Eisenhower Memorial. So if you're interested in an interesting meeting, come here on April 1st for that one. The commission reviews approximately 150 projects per year. So we'll talk about some of the specific issues related to projects that have been reviewed, and I'm going to race through these pretty quickly just because I don't have much time. How much time do I have?
Anybody's time and you
Oh, darn. All right, then I have plenty of time. So the National Museum of African American History and Culture, affectionately known as NMAC, not a very good, smooth name, but you know, we're bureaucrats. We like to refer to things by their initials. NCPC had approval authority over this project. It also had to undergo NEPA and Section 106 review. It's a very sensitive site. It's actually technically on the grounds of the Washington Monument. And it was not a project that the Park Service was particularly excited about having in that location. But it was decided that it would be there, and we have since then been working with NCPC and with many other agencies to try to make this the best possible building it could be, given the sensitive site, its adjacency to other federal projects, the view sheds related to the Washington Monument and the mall. Some of the things that we looked at carefully were the compatibility of the building height and bulk, vehicular circulation and loading and how trucks get in and out, landscape features, et cetera. This is an aerial view of the Intelligence Community Campus in Bethesda. Now, I don't know what's going on the left-hand side of the slide. It makes it seem like we're watching this from through the clouds, but it's an interesting thing because what you're seeing there is a whole lot of pavement surrounded by residential development. And then to the left side of the slide is national park land. So you have this convergence of issues having to do with trying to create a more sustainable campus. It is still a fairly remote campus, so you can't rely on people getting there by metro very easily. So you have to have a lot of cars parked there. And it's also, because of its proximity to these residential communities, there are a number of issues that relate to the potential impacts of this development or this redevelopment on those local neighbors. So we had some very interesting hearings on this topic as well. Of course, this is an area where the review was advisory, and it started with a master plan review, which is typical when on a site like this. NCPC reviews a master plan and then subsequently reviews the development projects within it for their compliance with the master plan as well as compliance with the comprehensive plan. Excuse me. One of the things that I should point out here is that the Washington area is unique in that it's one of the few areas where federal agencies have to undergo this extra layer of review by the National Capital Planning Commission, as opposed to simply complying with NEPA and Section 106 and other internal regulations within their agency. And it can be a little bit difficult when you're dealing with agencies or with facilities that might be managed by somebody who's used to operating in, I don't know, some western state where there's lots of land and there aren't a lot of people who are close by and closely watching, and they get to do whatever they want. And then general whoever comes here and is now in charge of a base. And what do you mean I have to go to NCPC and get permission? It's a very, very difficult thing. Now, of course, we also have that with the Park Service because we have superintendents who are used to working without that layer of approval as well. Of course, they have to be sensitive to neighborhood concerns, but it's a different environment here. Anyway, this was a very complicated project with stormwater management issues, and you can't really see it, but it slopes down to the left side. There have, over the years, been significant runoff issues having to do with that large parking lot and deep ravines that have been carved there by the runoff. And a lot of that was addressed in the process, and the DOD was very cooperative in the end in trying to work all of that to the best possible result. GSA Headquarters Modernization. You wouldn't think that you're looking at the bistro sink that you are actually looking at a federal office building. That's not typical for Washington. And that's what was really interesting about this project, is that under the current leadership of the GSA, they've been much more progressive about options for introducing ground floor retail into certain facilities. And this was a really good opportunity to do that, and it was a big part of the project. There were other areas that were about this project that were innovative, such as really trying to increase the efficiency of their space, putting using more open floor plans, encouraging telework, and hoteling of employees. So more employees will not have their own desks. They'll simply have a place to come and work and check in and get a workspace, and they can work when they are there. Is a much more efficient way of using federal office space.
Peter, this is you're treading on thin ice, and we need to move on.
Okay. All right, I'll move it along. So, Old Post Office Pavilion, Trump International Hotel. I'm going to skip over that one. Randall School, this was interesting because there was a Hyde Act issue here having to do with the penthouse. On the right-hand side, you can see the penthouse structure, and it was not set back in accordance with the requirements of the Act. That was eventually became a moot point because the project was completely redesigned, as we see on the slide below. But NCPC did debate it and did come up with a statement pointing out this problem. And then the Martin Luther King Memorial was one where I have some battle scars as an applicant. It was a Park Service working with the Martin Luther King Memorial Foundation. And things were going along fairly well, and then we realized that we needed to increase some of the security protections on the site, and it dragged things on for another year or so, but fortunately we came up with a design that satisfied everyone, and we got through the process. One of the things about memorials is that NCPC's authority is actually, by the Commemorative Works Act, goes beyond simply planning and does delve into design and durability and things like that, and so it becomes a more complicated process. So that's mine. Thank you very much. Sorry I ran over.
Okay, so if you're a lawyer, at the end of a semester in law school, when you're cramming for your law school exams, you used to go to the bookstore and buy what was called nutshells. So here's federal planning law in a nutshell, okay? The Planning Act confers authority on NCPC to devise a comprehensive plan, federal elements, to undertake plan and project review of federal and district public buildings and projects, and prepares an FCIP. There also are several important other acts, most notable of which are the Commemorative Works Act and the Hyde Act, and there's a federal rep on the Zoning Commission. Okay, next. Jennifer Steingasser is here from, as we introduced her, from the District of Columbia. There is a degree of synergy between the District Planning Authority and the Federal Planning Authority. So we thought it would be good to pair her and Peter together. So without any further ado, Ms. Jennifer, take it away.
Thank you. I'm the Deputy Director with the DC Office of Planning, and I'm going to talk a little bit about our relationship. You'll see a lot of the similar slide topics that Peter just talked about, because there is a great deal of intermingling and relationship between our agencies and how we regulate. So in the beginning of DC, there was height. And height was the first major issue that dealt with form in DC. And the 1910 Hyde Act basically set out some rules of thumb on how height should be regulated. It's the rule of thumb is street right-of-way plus 20 feet. It's 130-foot maximum in the commercial zones, 90 feet maximum in apartment zones, except for along Pennsylvania Avenue. Between basically 3rd and 15th Streets, it can be up to 160 feet. So that'll be good for your April trivia. Then came 1920, and the Zoning Act was adopted by Congress, and they created the Zoning Commission. And originally in 1938, there were 3 district commissioners which were appointed by Congress. There had to be 1 Republican, 1 Democrat, and 1 civil engineer. Party affiliation was not required. There was also the officer in charge of public buildings and ground and the superintendent of buildings and grounds. But today that's been, after home rule, which we'll get to, that's changed. So there's 3 mayoral appointees, which are then have hearings before and approved by the city council. There's the director or his representative of the National Park Service, and there's the architect of the Capitol. And those 5 people sit on the Zoning Commission today. In 1938, there was also the creation of the Board of Zoning Adjustment. And the Board of Zoning Adjustment serves as basically an adjunct, as the court described them, to the Zoning Commission. They hear appeals and variances. They're a 5-member board. There's 1 representative of the Zoning Commission who sits on the BZA. There is a member from the National Capital Planning Commission that sits on, and then there's 3 residents of the District of Columbia. Again, you see where the regulatory bodies always have a cross-representation between the local and the federal. BZA, as we call it, is basically the same as you will see across the country. They hear appeals to the interpretation and application of the zoning regs. They hear special exceptions. Those special exceptions are determined by the zoning commission who writes the zoning regulations, but they are heard by the BZA, so it's a little bit of a delegation of power. And they include both uses and building forms, so it could be building heights, building parking. They also hear variances from the strict application of the variance of the zoning regs, and this gets, in DC, it's a very strict set of what they call the tests. It has to be a nexus between a uniqueness in the property and an application of the zoning regulations, and it can't impair the intent of the zoning regulations. And then there's also the Foreign Missions Act. Excuse me. And the Board of Zoning Adjustment, its constitution is slightly altered when they hear applications from local chanceries to locate in the district or to move or to expand. And the composition then, it requires that the zoning commissioner be replaced by a representative of the National Park Service. Luckily, there is that one individual who serves both roles. And then the National Capital Planning Commission position must be represented by the executive director. And so we refer to this locally as the FM, the Foreign Missions BZA, and they only hear these foreign mission cases. So then Christmas Eve, 1973, Home Rule was adopted, and the district got its own authority. In terms of zoning, it became a really interesting time because the Zoning Commission was made a charter agency through the Home Rule Act. Again, the Home Rule Act was adopted by Congress, but it allowed a lot of exercise of rights to the district as a local government. What they did do through this Home Rule Act, which is really interesting, is the Zoning Commission maintained full authority over the zoning. So all the zoning powers are vested with the Zoning Commission. All the changes in a zoning map or text were required by the Home Rule Act to be referred to the National Capital Planning Commission for a review of federal interest. And then they changed the standard relationship of zoning to the comprehensive plan from being consistent to not inconsistent. And that double negative has created fun for years and years and years. So that's one of the most unique things about DC. According to our attorneys, it is the only jurisdiction in the United States where the legislature, which is the city council, has no authority or ability to zone. All zoning vests with the zoning commission. So whereas my experience in Virginia and Texas, where there was a planning commission and the planning staff would prepare plans, they would present to the planning commission, they would have their hearings, they'd make a recommendation to the city council would send it back, overturn it, do whatever they wanted to do, but they would hear the city council would make the final decision on zoning. That's not the case in DC. There's a complete separation of powers. So the other interesting thing is that the Zoning Commission has more power within its jurisdiction excuse me, than the City Council does. The mayor cannot veto the actions of the Zoning Commission, and Congress does not review the actions of the Zoning Commission. And that gets to a part of the Home Rule requires that the city, when they pass any legislation, including our budget, it goes to the Congress and has to be approved and reviewed by Congress. That's not the case for the Zoning Commission. So these 5 individuals have this unparalleled and unmatched authority in terms of land use and development. Planning, however, is the responsibility of the mayor and council. Okay, so the comprehensive plan, which you heard about from Peter's side, from the federal side rather, has federal elements and district elements. Excuse me, and the district elements address all lands except the federal lands and the federal facilities. So we basically regulate all the public lands. We embody our citywide policies. We do the ward level. The district's divided into 8 wards. So those policies are embedded into the district elements, and then there's the small area plans and policies. Those are also done by the Office of Planning and working with the communities. So,
this is another duty as a
oh, thank you. I know public speaking makes me clear my throat. So the planning process is a little bit unique in DC from the local side because the planning starts with the mayor. So the Office of Planning serves as the planning office for the mayor. He's designated as the executive planner of the district. So we work with the mayor under his authority to do the comprehensive plan. We work with the communities, hold all our public hearings. We hold what we call a mayor's public hearing, and then the mayor then submits that comprehensive plan to the city council. City council holds their hearings, they adopt their comp plan by legislation, but prior to it becoming effective or being forwarded to Congress, it has to come to NCPC. And Peter talked a little bit about how NCPC then can review it, can veto it. Overall, we have a very good and very strong relationship in how those two pieces work together. Last time we overhauled the comprehensive plan in 2006, we spent several meetings arguing back and forth over two particular sentences. And then somebody pointed out that we had also agreed on 380 different policy points, and that kind of took the heat off the issue. So there's a strong relationship on how those pieces work together. Then once NCPC has determined there is no adverse effect on federal interests, it's referred to Congress and becomes law. Now, this is the slide submitted by my attorneys, and they insisted I put it in there. So their nose is a little out of joint that they didn't get invited to present. So they're punishing us all. This basically just talks about the authority of the comprehensive plan. The city was challenged on the authority of the plan, and it was determined by the courts that it was not self-executing, that indeed the comprehensive plan has a presumption of on behalf of the city that there is consistency between the zoning and the comp plan, and that it doesn't require. Thank you. It's not require. Every individual policy statement is not self-effectuating, and it doesn't carry that weight of law. So there are exemptions to zoning in the district. The federal public buildings are absolutely exempt. The DC public buildings, being our schools, our libraries, those are all exempt and within the central area, and those central area are the downtown and the Shaw School urban renewal areas. These are still in existence. They expire fairly within our lifetime, but they're still in existence. But nobody gets a free ride in DC, so there's always a government waiting for it, and here it's called in lieu of zoning. And if you're not subject to the local zoning of DC, then you go into the NCPC approval process, and they review you. So you get a poison on either end. So when the zoning regs were adopted as we have them now in 1958, and in 1959 the DC commissioners exempted all district properties from, and by district I mean government properties, their own properties, from zoning outside the central area. In 1990, the city council felt otherwise and made themselves subject to zoning. So now, when you're outside the central area, the district government still must be consistent with its own zoning regulations, many of which didn't exist. So we would get building permits that would come through, and there was no zoning to allow for these things. So we did a series of emergency amendments in the early 20s to make sure that the city could actually build its own structures. The other thing we have in DC that's kind of interesting is the advisory neighborhood commissions. These were created in 1974, again through a referendum to the Home Rule Act. They are a local government body. Every 2,000 citizens in the district within a geographic boundary are entitled to a representative, a single member district they call it. The ANCs are they are required by law to be given great weight. And that doesn't mean that a decision-making body has to agree with them, but they do need to address why they do or do not agree with the positions taken. And that great weight is required by any decision-making body. So that would be the Zoning Commission, the Board of Zoning Adjustment, and if there's an appeal through permitting. The other interesting thing about DC that really affects how we develop and how we build is our historic preservation. These red wedges here represent the amount of historic properties and the amount of historic property owners in the district relative to non-historic properties. So 19% of the physical properties in the district are some type of historic or contributing property within a historic district. And 24% of our property owners live within a historic structure. So that's an enormous, and that, you can see the numbers there, an enormous amount of historic regulation that goes on in DC. This just shows a little bit of the trends on historic districts, how they came in. We have 55 historic districts within DC. 27 are what we call neighborhood historic districts, and those are basically either residential neighborhoods or commercial neighborhoods. 28 are other types of historic districts. They can be federal, like the White House compound. They can be Park Service. They can be campuses, Georgetown, for instance. And then they can also be military bases like the Navy Yard. So Georgetown is, the community is our first historic district in 1950s. It is also a National Historic Landmark, so it has multiple series of protections. When you're within a historic district, and Georgetown, for example, is subject to the U.S. Commission of Fine Arts. They've got an advisory board called the Old Georgetown Board that's established through the Old Georgetown Act. If you're in the Shipstead-Luce Act, which is a geographic boundary that basically follows the parks
and federal
properties downtown, anything that kind of interfaces with these identified federal areas are subject to Commission of Fine Arts. DC projects inside the central area are subject to the Commission of Fine Arts, and then federal government projects. The National Park Service also has a particular role in some of our historic reviews, especially they maintain the National Register of Historic Places and Properties, and if you're going after federal tax credits, that would go through the National Park Service. And there's also, they fund a lot of our state historic programs. And in DC, we serve both as a city as well as a state in terms of our State Historic Preservation Office, our state census office, and we have a Secretary of Education. So we do have 3 state programs that are administered through us. Then we have our own local DC Historic Preservation Board, and they review projects as well. They're a policy advisor to the mayor and the city council on historic preservation. And then there's the state historic preservation officer. This is a role that's outside of the municipal role. It takes the state role. It interacts with the federal government, looping back through the National Historic Preservation Act in review of all what they call Section 106. So again, there's this constant circulation of review and coordination going on between us. Other overlapping authorities which just make DC so much fun. The architect of the Capitol looks at Capitol grounds, and there's actually a zoning overlay through our local regulations that reflect their authority. The U.S. Secret Service looks at properties that are near the Naval Observatory and the White House precinct. We have a DC Public Space Committee which looks at sidewalk uses that are outside of building but within rights-of-way that are not covered by, that are not street or cartway. So all of the sidewalk cafes, things like that, those are regulated by the Public Space Committee. And then, of course, our Department of Consumer and Regulatory Affairs, which does all our permitting, and that's where the zoning administrator is located, and he does administration from there. And then also signs. They're done through the building code. So they would, a sign in a historic building would start there and then go back through various review processes. And so this is just basically our process in summary form. It had some pretty pictures on it, so we put it in there. It just kind of runs you through the basic process, small area plans, comp plan, zoning, get to your building permit. Some of the challenges that we've been working on lately have our inclusionary zoning, and this comes from part of our affordable housing policies. Obviously, anybody who lives in this area knows that affordable housing is next to impossible to find. We've been trying to work through coordinating some of our inclusionary zoning regulations with the federal regulations of HUD. Our AMI is skewed significantly inside the DC boundary versus outside in the regional AMI. We also have foreclosure and covenant issues, and that gets to some of the HUD funding issues. We have yet to figure out how to really successfully deal with condominium fees, especially in luxury buildings. We're requiring that there be some affordable housing depending on how big it is and what zone you are. There's a certain threshold and a certain AMI, average median income, that you have to target, and you have to set fees aside. But in some of the luxury buildings, the condominium fees can often, after a while, we are hearing that they can actually be higher than the mortgage payments. So that's a real issue we're trying to work through. Some of the things we've done to encourage maintenance of our affordable housing is we've done what we call a multi-property historic district designation. And these are properties that are not contiguous. There's a series of apartment buildings built in DC in the 20s and 30s. They're really nice quality. They're solid brick. They're mostly walk-ups. And in order to maintain them and discourage their demolition and relieve some of the pressure, we've created a historic district that defines them and allows property owners to petition to be in them. That makes them eligible for certain tax credits, and that helps. And then it's just looking at our inclusionary zoning as part of our larger housing policy. Sustainability is also something that has required a lot of the cross-jurisdictional work. We have to coordinate with our building regulations, coordinating with our transit opportunities, both in and out of DC, with our Department of Transportation, WMATA. We're also coordinating with the federal initiatives, the Southwest Eco District, which you heard about earlier. We were very instrumental in participating in that planning effort and working with them on how to address some of their development issues, incentivize the right type of development through our zoning, also through stormwater regulations. That's a huge deal with us in the district. We have some of the strictest stormwater regulations in the country, and so we're working very closely with EPA to get that taken care of. So the one thing I just wanted to add, again, for your April trivia contest, and speaking of law and order, in the district boundaries, there are 41 separate police departments. 28 are federal, 7 are district, and the remainder are the universities. All of these can ticket you, so when you get a ticket on your car, it's not always MPD. So remember that. Huh? Another reason not to own a car. And over 30 can arrest you. That's what it is.
Very good. I don't know, maybe I shouldn't step foot in the district again. I think something interesting that I recall from Jennifer's presentation is from the Home Rule Act history. You pointed out the autonomy of the Zoning Commission. Actually, at the time of consideration of the Home Rule Act, Congress gave serious consideration to establishing a format similar to what you're going to hear about in Maryland and Virginia, which is to place zoning authority. You could have this zoning commission sort of start the process. You would have these adjudicatory hearing officers hold hearings, and then it would go to the city council for approval. And the reason this was under consideration is, at the time, the Georgetown waterfront was undergoing a rezoning. And the citizens of Georgetown felt that this independent body was not being responsive enough to them, and that they wouldn't get that responsiveness unless you took it to ultimately to elected officials. But Congress, which we always must say acts in its own wisdom, decided to keep the structure as it was. So I thought that was kind of interesting. And now we'll hear more about that structure from David Lieb, who's going to tell you about Maryland. I can't give you a nutshell because we're running short on time. So you're on your own on this one. And Jennifer's too.
Okay, so we're crossing the district line now into Maryland. I have a few topics to cover, but very little time in which to cover them, so forgive me if I talk fast. I'm going to talk briefly about the origins of the Maryland National Capital Park and Planning Commission. That's the only time I'm going to try to say that because it's too much of a mouthful, and I'll just refer to it as the commission. I'm going to talk about the origins of it as a bi-county commission that covers Montgomery and Prince George's County. And talk a little bit about how it operates in performing its planning and zoning functions. I'm going to talk about the sources of the county's planning and zoning authority, and finally try to talk a little bit more deeply about the legal significance of master plans. Maybe I shouldn't put that there, do you mind? Okay. You can sign up for it afterwards if you want. Okay, let's see. Well, that's me. This map was really hard to find. It's the only one of its kind in existence so far as I'm aware. This map shows, as you can see across the center, the original Maryland-Washington Metropolitan Regional District, which was established in 1927 by the Regional District Act, which is still the primary source of the Park and Planning Commission's authorizing authority to do planning and zoning, and also the parks activities that they regulate. If you can see, I don't have a pointer, but it goes out at the very top there, it goes out just to the border of Rockville, and most of it is much further in. So you can sort of see this really, originally, as a bi-county commission, it covered just a very inner ring of outside of Washington, D.C., and it seems that it was assembled for this reason because of its proximity to D.C. and based on a belief that an area in that proximity to D.C. was a type of suburb that needed planning regulation in a way that the further flung, at that time, certainly rural areas of the counties did not need. If there were a larger map that showed all of Montgomery County, it would go up another couple of clicks there. Over time, the entirety of both, you can see, if you can see closely enough, some areas were added in 1931 and then later. But over time, the entirety of both counties were, with the exception of a handful of municipalities, came under the commission's jurisdiction. I think for anyone who wants to understand how the commission functions today, the simple thing to understand is that for purposes of day-to-day land use planning and zoning, and for most long-term purposes for that matter, Montgomery and Prince George's counties function separately. Each county has its own planning board, which writes master plans and does development review, and each county council determines zoning and approves the master plans that the planning board writes, is responsible for preparing. As a result, however, the history of the commission, that it is a state-created agency, the planning boards are technically not part of county government. So they function with a degree of independence, which is sometimes a source of tension. And for many matters, we are dependent on the county councils, including the appointment of planning board members and, importantly, our budget. Oops, how do I go back? Backspace? Look at that. Okay. What I have on the screen here are references to a couple of provisions in the Maryland Land Use article. At the top are provisions that come from the Regional District Act of 1927, which a couple of years ago was recodified into a land use article and combined with the other planning and zoning authorizing statutes that applied throughout the rest of the state to what are referred to as single jurisdiction planning and zoning areas. So if one were to look at those provisions, you'd see in the provisions at the top that come from the Regional District Act, the elements that must be included in the general plan and zoning powers and purposes, you would see some pretty general, broad language. And in the provisions below, I think what's really sort of interesting to note about these is that the provisions below that don't pertain specifically to the commission, they pertain to the other areas, but to make matters somewhat confusing are nonetheless applicable to the Maryland National Capital Park and Planning Commission. The provisions on the bottom contain what I would describe as some of the sort of smart growth, heavy lifting that's taken place in recent years in the Maryland legislature. To sort of draw a little bit of a contrast between these things, if you look at the Regional District Act and the language that's still there, in explaining the purpose of master planning, it says simply, the orderly development and use of land and structures requires comprehensive regulation through implementation of planning and zoning controls. And it goes on to talk about a number of different elements that you can include within a master plan, but it says you may include some of the things that you might want to include in your master plan might have to do with some of these things. It doesn't say, however, what you have to do. The provisions that have come later, and especially some provisions coming from the SMART and Sustainable Growth Act of 2009, which was adopted in the aftermath of the Terrapin Run decision, which is something that you may have heard of, are much more prescriptive. The Terrapin Run decision, in a lot of people's view, sort of dumbed down the significance of master plans, and the state legislature quickly swung into action to substantially reverse that decision. And just to give you a little bit of a flavor of it, 1201 there contains these visions that a planning commission shall implement through a comprehensive plan, and there are a number of them. They pertain to quality of life, public participation, growth areas, infrastructure. Under community design, it says, just to give you an illustration, compact, mixed-use, walkable design consistent with existing community character and located near available or planned transit options is encouraged to ensure efficient use of land and transportation resources and preservation and enhancement of natural systems, open spaces, recreation areas, historical, cultural, and archaeological resources. Wow, who could disagree with that? But it reads a lot more like a sort of smart growth manifesto than anything that came in some of these older provisions that have guided planning in Montgomery and Prince George's counties for a long time. Nonetheless, even without those strong smart growth admonitions, as I think Montgomery County has, speak especially for Montgomery County where I work and am most familiar, Montgomery County has a reputation for doing planning on steroids. We have a general plan which was passed in 1961 and since then has been amended umpteen times by area master plans, of which we have, I've lost count, but it's something over 30 that apply throughout the county and are updated approximately every 20 years. And that's the source of a problem that I'm going to touch upon briefly as I move forward. So now I want to shift to sort of delve a little bit more deeply and talk about master plan conformance and the legal significance of master plans. I was delighted to have an excuse to put this image into a presentation. For anybody who's familiar with Bethesda, that image on this plan, which is a 1970 Bethesda Chevy Chase master plan, is the Madonna of the Trail statue, which is in downtown Bethesda. But the thing that, and I don't know much about the history of the Madonna of the Trail. I gather there are like a dozen of them going across part of the country, memorializing something or other. But what? I'm just trying to own up to my ignorance here. But the thing I love about this plan is the way that it's this negative image of the statue. It's just like, it's very rad. And like now master plans are all just sort of pictures of pedestrians happily walking along, swilling their coffee on by some awnings. And I just think this speaks to a very different notion about planning. Okay, so I was sort of asked to talk about the issue of master plan conformance. I think possibly by somebody who had an idea that about this Terrapin Run issue, which was, again, this very controversial court case in which somebody said that the requirement to conform with a master plan didn't really mean that you had to conform to it. You just had to be in harmony with it. And that just set people's hair on fire. So do master plans, one of the questions I was asked to answer is, does zoning have to comply with master plans in Montgomery County? And the short answer is yes, usually. As a rule of thumb, Euclidean zoning with all the off-the-shelf rules, with narrow exceptions, must be consistent with the master plan. When a master plan gets approved, the next step is to rezone property as recommended by the master plan. Some zones contain a specific requirement to be applied only if recommended in a master plan, which would have been something that county council members were convinced to put in just to ensure that some horrific zone wasn't going to be visited upon a community without it having been recommended in a master plan. But it's also the case that Maryland courts have held that localities have the power to rezone property to be different from what a master plan recommended, as long as it is part of a comprehensive rezoning. Again, usually the comprehensive rezoning tracks what's in the comprehensive plan, but it can all get very comprehensively confusing. And just as another note, floating zones, that's what we call them in Maryland, but that's typically your planned development type of zone, have to comply with master plans less often, but they nonetheless do sometimes have to comply with master plans. Going back for a second to the Smart Growth and Smart and Sustainable Growth Act, and the requirement for one of the things that it says is that zoning is supposed to conform and advance the objectives of master plans. I just mentioned these court cases holding that sometimes a comprehensive rezoning can depart from a comprehensive plan. And as far as I'm aware, the ability to rezone to something different than what a master plan recommends has not been tested since the state adopted stricter standards for master plan conformance. So I think there may be some arguments about that down the road. And I think when that happens, it's going to be interesting. And I have a feeling that courts are going to want to, despite the language in the state statute mandating this level of conformance, I think courts are still going to want to find a way to defer to local decisions about what they want included in their plans and what they want, how they want their zoning to reflect that. And I think that it's going to end up having to do, the argument's going to end up having to do a lot with context. Okay, this plan, this is also from Bethesda. All my examples that I'm talking about tonight are from Bethesda. Do you all like to make fun of master plan folly or planning folly? Because what this is, this map is from 1976, Bethesda Central Business District Master Plan. And you can see down at the right, it says above grade pedestrian circulation. All those black squiggles across that map are elevated walkways that were supposed to be going through around all the buildings so that we could all live like gerbils. And anyway, I just think it's kind of hilarious. So when I'm talking about the need to conform to master plans, and I dig out a master plan and I find this, I sort of, I have to hesitate for a second about the wisdom of strict conformance to master plans. Because as some of you may have experienced, sometimes it's hard to figure out what a community is going to want or not want 20 years from now, precisely. How am I doing for time? Speed it up? Okay. All right. One of the things I want to touch on is, as somebody mentioned, I worked on Montgomery County's zoning code rewrite, and we're fundamentally rewriting the code. Some zones are being retained, but most of them are being changed in some fashion, or at least subject to some new naming conventions, even if the underlying standards of the zone are hardly changing. And what's going to happen after the zoning code rewrite gets adopted is that there's going to be a countywide rezoning, so this whole thing will take effect. Excuse me. Some argued in this multi-year process that the zoning code, the new zoning code, should only be applied in those new zones mapped onto the ground through a master plan process. So it was only as each successive area master plan came along that the new zoning code would take effect. And instead what's going to happen is there's going to be what we refer to as a district-wide map amendment. And all in one fell swoop, the county is going to be rezoned. It's going to be amazing. And there are debates about the legality of all that. And what we're going with is that Maryland courts have said it's the plenary power of county to engage in a countywide rezoning, and so that's what we're doing. The comfort for people who are concerned about this rewrite and its impact and the level of its fidelity to master plans is that the zoning code rewrite was undertaken with a great deal of exacting fidelity to master plans, perhaps more than we'll learn turns out to be wise. I'm not sure. But so it's sort of a legal, maybe only a point that a lawyer could appreciate, but there I go. One of the other things that I observe about these debates is that these debates about whether zoning must comply with a master plan frequently seem to ignore that zoning can change. I mean, the name of the zone on the ground can stay the same, but you can add uses, you can change the development standards, and you're still nominally complying with the master plan. So it's a debate with some sort of funny wrinkles. Okay, this is my last slide. Apart from zoning, master plans play another very important role in Montgomery and Prince George's counties, and I would be inclined to talk a little bit more in detail about Montgomery County because this is a nuanced issue and it's what I'm most familiar with. At many stages in the development review process in Montgomery County, whether you're going through subdivision or now in some instances site plan, there is a requirement to conform with master plan recommendations. And the reason why that's significant is, notwithstanding what the zoning says, if the zoning says you can build to 200 feet, if the master plan says for that site you can only build to 100 feet, you're stuck at 100 feet. Maryland law has held for a long time that a master plan can undercut what a zone allows. So if the master plan says you should only be able to build fewer units there, if it says you can only build lower, you're subject to that. In some instances, the zoning code in our jurisdiction will actually allow you to exceed the heights recommended in a zone if the master plan recommends, or allowed in the zone if a master plan recommends, but those instances are more rare. Okay, so this picture, just to sum up, in the sort of foreground of this picture, you can see a little clock tower. That clock tower is attached to this lovely sort of brown glass terrarium building this sits right on top of the Bethesda Metro in downtown Bethesda, and that building was originally a food court. And it was built at a time when food courts, as I understand it, were very trendy by somebody who had worked with the Rouse Company in Baltimore, and I think based on the experience with the National Harbor, which when I was a kid growing up in this area was this awesome food court. They made this food court. Anyway, and when they got around to doing a new master plan for the area, they said, well, there's a food court there. It's a happy, functioning food court, and we will recommend that it be zoned, that part of this plaza, which is be a retail service area with limit of like a 2 FAR. The property owner here came in and wanted to redevelop that building, which at the time was vacant, and they wanted to put a 16-story office tower there, which ruffled a lot of the neighbors' feathers, but I think it's hard to argue it wasn't a smart growth move. It's right on top of Metro, and there's also a bus depot under there. So it was a good location to add density, and they went through the ringer to try to ensure that they had enough tract area to draw the FAR off of. They were going, as I understand it, they were going back through land records dating back to like colonial times to say, the road bed out to the other side of the street used to be associated with this property, therefore we should be allowed to draw density off of that, and it was just this whole huge thing. But then when it finally came in before the planning board smacked it down because the site was recommended for retail and service uses and not a tower. And so I will always remember this as the smart growth opportunity that went down for the sake of a food court.
So one of the things that has always intrigued me about Montgomery County, or as a resident I frequently refer to it as the Republic of Montgomery County, is we have two very highly urbanized areas, Bethesda being one of them, which is unincorporated and does not have its own government. The county does its planning. Then you have Chevy Chase Section 3, which is a residential development, Chevy Chase Section 4, Martin's Additions, all up there in the Connecticut Avenue corridor, which managed to incorporate themselves into separate governing entities, have their own little mayors in certain jurisdictions. I believe the county still does the planning for them, but What's going on with Bethesda? Who knows? Okay, Sharon, we're going to turn it over to you. Oh, I see a slinky. This looks cool. Just for the sake of everybody, we got started a little bit late. I know it's 7:15. I'm not going to get to realize my bucket list goal because I'm not going to get to sit with schmooze with my panelists because we're going to go right to your questions after Sharon. So stick around with us and this will keep going.
They always say lawyers are boring, so I bring my slinky as well as my code book. We're going to talk about Virginia law pretty quickly. And it's nice to be able to be on this panel and learn more about Maryland and DC and planning there, because as General Counsel for the Metropolitan Washington Council of Governments and working with Region Forward at COG, it really helps me to know more about what the other jurisdictions' legal bases are. And I will note that Chuck Bean, Executive Director, is here tonight, and Paul Desjardins, our Planning Director. And having said that, I now disclaim any connection to COG for what I'm going to talk to you about, because I'm going to talk to you about Virginia law, and I'm going to go really fast. 9 minutes maybe at most around the world of land use in Virginia. They're catalysts for change, and yet some people think that in Virginia nothing can change because of the situations there with respect to the law. And so what you're going to hear is a little bit of irreverence, although I might say, and those Virginia planners who are here might agree with me, that that inspires creativity. So while you may think that in Virginia things are stodgy with respect to the general authority that we have in the state legislature, and we'll talk about that cursed rule in a moment, you have localities like Loudoun that have just been able to facilitate the construction of 2 major roads with a major mixed-use facility using one of the first Virginia transportation infrastructure bonds in Virginia, and accomplishing that with a mixture of planning, creativity, and ideas. And I was fortunate enough to work with the Loudoun County Economic Development Authority on that to make that all happen. So if you're going to go on this planning venture in Virginia, you need to see what you need before you take off. How far in Virginia can localities go? That's the big issue. The quote-unquote rule that's the big bugaboo in Virginia is the Dillon Rule, which says that localities have only that authority that the General Assembly gives to them, as opposed to home rule, where arguably you have all the authority that you want, unless the government, the state government, takes it away. So my question is, does it really matter? In Virginia, if you look at the chapter on planning and land use, and you read it, and the introductory sections are based on what was a general standard in the state, in the nation, that was developed years ago, you will see that there is very broad authority. So my question is, does it really matter? My answer is not necessarily if you are careful. So Virginia has broad enabling authority with significant restrictions, and then, as we call it, new guidance from the General Assembly. It's a waltz in Virginia, and what you see in the Northern Virginia region are localities that have learned those steps quite well to accomplish what they've done today in terms of planning. In Virginia, I can explain to you land use law with a slinky. And this is very important because this is exactly what the state code says, although you won't find the word slinky in there. Comp plan, zoning ordinance. Actually, I have my 2 slinkies. I'll pull out the one. Comp plan, zoning ordinance, subdivision ordinance, development regulations, and capital improvement plan. And if you link all of those together, I'm going to let Peter take apart my slinkies. If you link them all together in Virginia, then you can accomplish what you set out to do in your comprehensive plan, unless you've had a little bit of that guidance from the General Assembly. So, first issue is, in Virginia, everybody goes, okay, Dillon Rule applies because it's a rule of interpretation by the courts. So the court goes, the locality did what? In Virginia, the general rule is that there's a presumption given to the locality on the substantive decisions of local governments. Very strong presumption. However, procedural deficiencies can be fatal. And every once in a while, the Supreme Court in Virginia finds procedural deficiencies, which maybe was sort of their way saying, we weren't feeling real comfortable with this. And so, well, a Loudoun County judge might think that he knew where Western Loudoun was when they did their downzoning plan some years ago. The Supreme Court said, don't think so. That ad must not have been right. It was a procedural problem. So they had to go do it again. And to Loudoun's credit, they've done a lot of comprehensive planning. Also in Virginia, there's a disfavoring of downzoning, and I won't go into the depth of that. We can talk about that later. So how do you get through the procedural issues and sustain good zoning in Virginia and zoning decisions? You create a record. Remember that there's a legislative presumption, and you pay a lot of attention to the procedural process. So the obvious thing that we see when the Supreme Court starts saying, maybe there's a procedural issue here, and not going to give the presumption to the substantive decision is the balance right? And that's the same thing that happens down at the General Assembly. And we as localities from time to time, my clients get upset because somebody has a zoning issue in the locality, and what do they do if they don't like the decision? They may not sue. They may go running to court. Excuse me, they may go running to the General Assembly instead of running to court, so they're going to like trump the fact that there in fact has been authority. And so recently the Virginia General Assembly has been wrestling with some legislation that will mess around with local government zoning authority again on the issue of, first started out whether a local government could accept cash proffers that had already been agreed to. All the developers were bringing in the money and the local government was just taking them, and the Supreme Court said, no, maybe a problem there. Rather than going back and working with the legislation to straighten it out, we feel like now the General Assembly maybe is going to take some action that says, if you even have anything that looks like an unconstitutional condition proffer with respect to your action on land use issues, you might have to pay attorney's fees if it goes to court. A little frightening. So the other is the ballot box changes, and if you look at many of the localities in the outlying parts of the capital region, the Northern Virginia area, you will see that there are often flips in terms of who is elected or re-elected. Not necessarily parties, but more growth versus non-growth. So back to my issue. Thank you. I'm good now, yeah. Comprehensive plan. As I said, that is the guide. It sets your coherent policy. In Virginia, unlike maybe in some other areas, it's a guide. You're not mandated to follow it. But in Virginia, every locality does have to have a comprehensive plan. Consistent adherence to the plan is the best possible thing that a local government can do to back up, make defensible, particularly in court, their actions. Failure to follow it doesn't make it illegal. Now, what's at the other end of my slinky? The capital improvements plan. And only in the most recent years have a lot of the jurisdictions figured out that if you put stuff in the comp plan at the front end, you need to figure out the funding at the back end. Or, as we did years ago in Prince William when the view was that we had down plan, down zone half of the county, the question was, what happens if we put into place the plan we have right now? How much is it going to cost us? So it wasn't so much just a question of growth versus non-growth, rural versus urban. It was a question of, could we afford it at the back end? And yes, there were ways to do that. Proffers was one of the key ways of doing it. But once you pair it that way, you get something that is very realistic. And when you make the discussion with the public, which I also is what you need, and you talk about what things are going to cost, not only just to the taxpayer, but to the developer and to everybody else involved in the process, Then you get to this comprehensive plan. It's also critical to use the CIP because issues such as CAS proffers and impact fees, which localities are allowed to impose in Virginia, are linked to that. It's also important, as I said, not only can you afford it, but it becomes the means of determining where you want to focus public facilities to accomplish your goals economically and otherwise, transportation-wise, efficiency and energy use, all of those types of things. You can accelerate development in areas to accomplish those goals if that's a good idea, the smart growth approach. Or, on the other end, you can say, nope, not ready to go there. We're not going to pay for public facilities there in our CIP. If you don't do that, you can end up coming up really short. The zoning ordinance. This is the key regulatory structure in Virginia in terms of doing land use implementation through the zoning ordinance. And that's where you have to focus if you want to do smart growth in Virginia. And I'll tell you in a moment why you can't do it at the subdivision stage. If it is consistent with the comp plan, again, remember, it makes it more defensible. Key in Virginia, it can't be purely aesthetic. And that may be a key difference to some other areas. And it can't be socioeconomic in disguise. How do you get to a bullfight in Virginia? Try doing a moratorium. Yeah. That definitely does it. Also in Virginia, you cannot do emergency zoning ordinances. Now, those who are creative realize that every ordinance is an interim ordinance until it's changed. And so you go through the process of thinking about how you make incremental changes that might address some particular issues. Key things are how do you condition development in order to mitigate impacts. Special use permits have been pretty good, pretty productive ways of doing those, although the problem in Virginia is that you are limited to nexus type issues. And I'm being broad brush on this as opposed to general. The good side for the localities is that the permit holder doesn't have to approve the conditions. We found that when we've had some very sophisticated conditions, in some cases we've had conditions that gone on for 4 or 5 pages, it's a good idea to get the permit holder to say, yep, that sounds good, I'm not going to challenge you on it. It will be even better if the court puts into effect this threat of attorney's fees. But there's some limitations for by right subdivisions and for clusters, and the cluster ones are problematic because of can create problems in limiting your ability to do some smart growth. Proffers, which are really should be close, near and dear to the heart of Northern Virginia, came out of years of what I would call a war between Fairfax and various developers back in the 70s and the 80s, and finally legislators got together and said, this can't go on. It's costing everybody too much money in litigation, in inability to determine timing on development, and so proffers came out of that. And those have been a really good ride for localities that have worked on them thoughtfully, made them consistent with their comprehensive plan, accepted them in addition to zoning regs and not in lieu of them, and refused proffers that developers offered that really just didn't accomplish their goals. The downside is that few people have complained about proffers being extracted from them. No, I used my example when I was talking about this years ago. It's like an engagement ring. Mm-hmm. You know, you're just talking, you're asking the person who's going to wear it what they want it to look like, which is a pretty good idea if you're going to be stuck with them for a long time. Okay. Examples of broad proffers, cash contributions, dedications. Down at the bottom, better design. You are seeing a lot of proffers in Virginia that relate to that. And then I've given a list of the types of proffers. Right-of-way dedications are pretty important. In fact, in Prince William, we had a right-of-way dedication. It was made years ago. We hit up against what I will call the historic sort of countervailing force that came in, and the federal government took the land to expand the Manassas battlefield. And then we actually got cash from the federal government for the land that they had taken that we had gotten in a proffer. Long way, hard way to do it. turned around, used it to actually create the Prince William Historic Preservation Program. But there are a whole host of things that have been done in that regard, become more relevant to issues of how you're doing energy efficiency, community design guidelines, affordable housing, and all of these things and more are being done throughout Northern Virginia. So that when you hear, for example, that Fairfax County has downzoned or has rezoned a lot of property around Tyson's Corner, you will see as part of all of that multiple proffers. When you hear that Reston is getting 22,000 new homes because of approvals by the Board of Supervisors, you will see lots of proffers. When the U.S. Patent and Trademark Office went to Alexandria, and it's located on private land, at least at the time it was initially approved, you had a metro station there. You saw a huge number of proffers attached to all of that, and that is how the localities in Northern Virginia have been making growth smart. But you have to do it carefully, and as I said, the legislature's been watching closely. There are some limitations. The legislature has incrementally over time put some more limitations on proffers based on some people going down and complaining. Subdivision ordinance. Many places in Virginia only had subdivision ordinances for a long time, and it is a very poor tool because you cannot do the creative things with respect to land use planning that might be in your comp plan through the subdivision ordinance. It's not allowed. You're not making that jump in Virginia. And if you had properties that been subdivided for many, many years, you had serious problems with being able to do smart growth. So for example, we had one of the most important historic sites in Prince William County that was surrounded by vacant land, and then a subsequent developer came in, wanted to use the subdivision plan, and we were going to have houses all the way up to almost the front door of this historic structure. Couldn't do anything except when we found that the developer had in fact submitted misrepresenting itself on the subdivision plans and had stormwater management ponds showing on one plan. Another plan for an adjacent property didn't show the stormwater management plan on it, and so we ended up being able to at least deny approval of the subdivision plans, which then led ultimately to them working out a situation that was rather nasty by giving us buffers. But that's the hard way to do it. You simply can't do much with just subdivision or site plans in Virginia. So you need to have the link, or you're stuck with that very significant limitation at the subdivision and site plan stage. Prime consideration in Virginia in making a zoning decision is consistency with the comp plan. But there are other tools, and I'm not going to go through all of them, but they're important because they allow localities to time development and make it more concurrent with the public facilities that serve it. As I said, you've got to do the linkage. You can deny those reasonable rezoning requests that are inconsistent with the comp plan. And those other tools, and I kind of use my box of pencils, even though it's rather antiquated to have pencils now, because every once in a while the General Assembly starts taking them away. And so you're sitting there as a planner in Virginia, and they're pulling away your pencils, but you still have some left, and you sharpen them a little bit more. So here are some examples. If you add public-private partnership to whatever particular land use action you're taking, it gets more of a smile from the General Assembly, and it appears from the courts as well. So keep that in mind. Overlay districts, there are increasing number of overlay districts that are allowed in Virginia, and that is useful for doing some specific planning. Partnerships, as I said, public-private ones. Service districts, community development authorities are kind of a hot item right now in terms of making development that might otherwise financially not work, but is sound from a planning standpoint go forward. Tax increment financings are similar. You just have to watch on those that, in fact, the proffers you're getting are not being paid with taxpayer dollars. Okay, some things that are hurdles. There is a really strong axiom that I will use that applies many times in Virginia, and you have to be careful, and that is if you use one of these land use tools, you may lose it in the next General Assembly session. So you have to be careful of that. That's why it's very important to keep up this dialogue and consensus both with the applicant and with your public and working off of your comprehensive plan. The other is if you mount that hurdle and you're really creative, then the General Assembly might raise the bar a little higher, which has kind of been the issue with respect to impact fees. Some challenges and opportunities. One of the good things is that the Virginia Department of Transportation, the Commonwealth Transportation Board, have increasingly linked land use to transportation, and so they have corridors of statewide significance. They look more at that, and now the state code actually requires that those corridors and that major state improvements be shown in comprehensive plans. Kind of hurts from the local side to be told what to do, but ultimately is really good in terms of those links. Urban development areas has been a bit of a challenge, but the General Assembly realized they tried to micromanage and didn't work too well. Stormwater management regulations are sort of the big issue that we're all dealing with throughout the region. May lead to some much more creative, better planning, but it's going to be real painful in the short term. Again, can't say it too many times, linkage. If you link, you can make it work. If you try to just extract and go in and do surgical work with respect to planning in Virginia, it's more likely to be struck down. So, you have to creatively address the challenges by using the comp plan as a guide. And then I must give my credits to Jules Verne, who gave us imagination, and to all of you planners out there who continue to do that. To David Nevin, who surely would have gone from supervisor to governor. And finally, my favorite planner, Jackie Chan. I don't have the great pictures that the planners on the panel have had, but I am just constantly intrigued at the way that the planners that I've worked with have been able to come up with creative ways for us to put together this toolbox in Virginia. And you see the benefits of that with some really good planning in Northern Virginia. Thank you.
I would encourage you all to stay. We're going to do a Q&A from the audience. Panelists, you're not going to go up on the podium. We're not going to take the time to recreate a new venue for our discussion. Turn on your mics. We have some folks that are going to be roaming the audience, so if you have a question, raise your hand, and somebody will come find you. Questions? You guys did such a good job that.
Looks like we have a question.
Is it on?
I don't think so. Is this on?
Yes.
There we go.
This question is for Peter May. He talked about the lands that were acquired through the Capra-Cranton Act, and I believe some kind of ongoing federal interest in that. I'm curious about the local parks in the District of Columbia, which were transferred, and I don't know the legality of, the legal details of that transfer, but local parks that were transferred to home rule. Is there a continuing federal interest exercised through NPC in the sustainability of those local parks?
So I believe this microphone is on.
We have our, okay, so you can turn what you're wearing off. Oh, okay, and your podium mics are on.
Okay, so in a broad sense, yes, I think there's an ongoing federal interest, but I think when and there are certainly some local parks that are currently under the jurisdiction of the Park Service that will remain so for the foreseeable future because they have an important role within the national park system. When it comes to smaller, triangle parks and things like that, a number of those have become the jurisdiction of the district, and we are, I think, collectively very interested in maintaining the role of those parks, but it is more of a cooperative effort, and it's not a matter of sort of a specific legal authority. Occasionally, some of those lands have been transferred to the district's jurisdiction with some strings attached. Certainly, they've been transferred with specific use in mind. But we actually have a very, I think, cooperative relationship with the district when it comes to the use of some of those and those parcels that have already been transferred. So.
Are you involved at all in the local parks? The district is doing a lot of redoing of its local parks.
I'm sorry, I couldn't quite hear it. Maybe you need them.
The district is currently engaged in a project that involves a lot of redoing of the local parks, redoing, replanning, but I wondered if you're involved in that at all, in a
Yes.
cooperative way.
Yeah, we have been, I've been part of a steering committee or something like that for the Parks and Rec Master Plan, and have been to many meetings on that topic, and a lot of the information that they're using is useful to, that they've developed is useful to us, and we've tried to contribute where we can on that. And we see this as a building block along with NCPC's capital space plan to advance the discussion and really try to get to a better overall system for the management and use of those smaller parks.
Thank you. Other questions?
One over here.
It's on. I guess my question is actually for Mr. Lieb. Actually, I came down here because these are the three jurisdictions. I've been a planner in Maryland for 30 years, and these are the three jurisdictions I have no experience in. And one is Maryland National Capital Park and Planning Commission, which has almost, their planning rules have no relationship practically to anything else that happens in the state of Maryland. So I was fascinated by your focus on the consistency requirement in the 2009 legislation was passed because the state got excited about a rural subdivision in far western Maryland. You said it hadn't been challenged, and I was wondering if you had an opinion as to why, because my view is the reaction to it everywhere else in Maryland is a shrug and, oh well, okay. It didn't mean a whole lot in terms of the way day-to-day business was conducted, but I wonder what you think its application is in Montgomery and Prince George's County.
Right. No, it's a good question. So the Smart and Sustainable Growth Act, again, sort of put these, I would say, establish more rules governing what plans look like. It made it, it's now, the state law is now more prescriptive about what plans need to include and what policy direction those plans should take. And then there's also on this issue about whether zoning is supposed to comply with the master plan. There is some ammunition in the Smart and Sustainable Growth Act to argue that, yes, it must. In terms of what I was trying to refer to is, I haven't seen anybody, nor read any, nor found any case where somebody has gone to a planning commission that was preparing a master plan and said, the vision statement in the Smart and Sustainable Growth Act says that, design must meet these 8 different objectives, and therefore you must devise your plan in this way, and it has to contain these types of recommendations. I haven't seen somebody try to do that. Why that hasn't happened, it may just be that it's going to be a matter of time, but my suspicion is, again, that as I tried to suggest, that notwithstanding the degree of prescriptiveness that was added into the state code, courts, and I suspect most people who are intimately involved in land use suspect this to be the case, I still think there's going to be a high degree of deference to local legislatures in Maryland who ultimately are responsible for adopting master plans and adopting zoning. They are acting as legislative bodies, and legislative bodies have a lot of leeway to do their work. And so I think that that's going to be the case. I know there have been some issues recently, I want to say in Charles County, related to some tensions between keeping some areas agricultural, and I'm not familiar with those. So those may be bringing some of these types of issues to a head. In Montgomery County, I don't think it's been such a big issue because a lot of what the state act calls for is stuff that the county is already doing for the most part. and has been doing for quite a while.
Another question.
We have one way back over here.
Oh.
Thank you. My only experience with proffers in Virginia was that the nexus between the problem and the money had to be very, very close. Is that still the case, or can you use it for broader planning initiatives like bike paths? And
There are several types of proffer authority in Virginia, and the broadest proffer authority, which would apply to the Northern Virginia area, is not limited to a direct nexus.
Another question. I saw a couple hands. Gentleman in the end, didn't you not have your hand up at one point?
Here you go.
Yes, I'd wondered. It's a broad philosophic question, perhaps. What does history have to do with anything that you've said? That is, history as a persistence, as a familiarity, as we've been here. We know that our physical surroundings are where we actually live. Washington, D.C. is now 100 miles across. It is almost as big as Los Angeles County. I have a man who's moved to Staunton, or Stanton. I understand you say Stanton. Because he cannot bear the District of Columbia, nor any of the areas that you are familiar with. I grew up in a place called Washington. It is 1,000 years old. It has nothing but 1,000 years history, naturally. But again, I ask, is the nation's capital an historic area, or is it simply a development area? As a development area, it is naturally different. Come 15 years, it will be different again. There is no persistence. And what I'm asking really, as a historian, is whether Washington, the counties you represent, the evident competence you all have, is wasted if it produces nothing but something good which will be there tomorrow, which wasn't there yesterday. This is a sentimental question, naturally.
I'm not sure I understand that question. What is it you're seeking? That the past should not inform the future, or the past should inform the future?
I'm saying that the present should, perhaps more prominently, take the past into itself. That the projects that you represent, which are great projects, better houses, roads, commuter traffic in the morning, but which undercut every sense that anyone coming, say, from Illinois comes to Washington to see history. What does he see? Not history. It is development. I'm asking, and this is a general, I began as a historian looking at Reston in 1961, a little time ago. And my question is quite simply, where is his history felt, experienced, absorbed, inherited, understood, felt? Where is it in what you are now so competently representing?
Sir, you are asking an incredible philosophical question. And I am going to suggest to the Office of Public Engagement that maybe we consider that for another speakers forum, because I think we could be here rather late discussing and debating that. I'm not trying to dismiss you. I just don't think that it's a very thoughtful and it's a very philosophical question. If you could come up, if you want to ask something more concrete at this hour, I think these folks would be happier.
I'm not a lawyer, and I do not get paid to becoming.
Well, I actually remember you from some of our height meetings, and I do know that the Washington you are from is not this Washington, is that correct? You're from Washington in?
County Durham.
Right, okay. Please, no insult intended, but we're going to move on. Anybody else? Another question? Yes, I recognize you. How are you?
Hi, how are you? My question is for Jennifer, and it has to do with the growth in the District of Columbia and the rapid change that's occurring with the major influx of people now, how the district is growing, and how would this growth be reflected, I guess, probably in the new zoning regulations? For example, I would imagine that increased density would now be needed, for example, to accommodate this incoming population, and will the new zoning regulations try to accomplish, for example, additional density, as one example?
As much as I appreciate the opportunity to put a plug in for the new zoning regulations, because we have a commissioner and it is an active case, we've agreed we're not really going to talk about that. But density would be driven from the comprehensive plan originally, and so we would look for ways that the comprehensive plan would accommodate growth and density, and then we would look for how the zoning regulations could implement that. I can't really talk about any specifics because it is an open case, and one of our zoning commissioners.
You want me to leave the room?
Let me just add on to the question. Will you need to do further or additional comp plan work to get to that issue of the need for additional density?
Well, the comprehensive plan right now is a very broad document, and there are many areas where the zoning and the comprehensive plan density have opportunities.
So you have some
Yeah.
room for growth
So we'll
there.
be looking at that. We will be looking at the comprehensive plan in the next year in ways, so they'll be more neighborhood focused. Where is it appropriate? Where could zoning enable more growth?
Okay. Sorry we couldn't be totally forthcoming, but other questions? Woman over here?
Thank you. This has been very interesting. I wondered if, Sharon, you could address how maybe you've seen changes since the Kuntz decision?
Yes,
Could you tell us a little bit, just summarize, Sharon, could you summarize first what the decision is? Okay.
Really briefly, the Kuntz decision was a decision by the United States Supreme Court that said that there was an exaction when a government asked a developer that was appearing before it to provide wetlands mitigation. And the developer refused to do it and then sued. I don't think that we have fully sorted out what it means. I will tell you that the political implication in Virginia has been the bill that I referred to that related to proffers, both to some issues with cash proffers, but also it was heralded as addressing the Kuntz decision. Our view is that really that decision doesn't have any relationship to the Virginia law. We had the same problem with the Kelo case out of Connecticut, is that related to Connecticut. It didn't have anything to do with Virginia law. So in the short term, it's a political fallout. In the longer term, I think it's going to cause localities, in Virginia at least, to be more careful in how they are interacting with applicants for developments that are coming before them. And with respect to proffers, those have to be voluntary anyway. So my view would be that the system simply is different than was in the Kuntz case.
Oh, interesting, very interesting. Other questions, comments? Last call. Okay, and with that, I say good night. Thank you, everybody.